that's different.
The claim of a hearing is what I was asking, whether that was supported in the statement of the court.
No, that's not submitted in my court statement.
Okay. Representative
Thank you, Mr. Chair. Just for clarification, and what was the total fees of the guardian ad litem on this in your particular case?
Overall, considering what she says I owe her right now, it's about $41,000.
Well,
So it's about 41. It's about $40,000 more than the fee cap provides.
thank you, Mr. Chair. And in that amount that is owed, how much is the other side responsible for that debt, or is that all?
No, I'm responsible for all of it. I was.
And Mr. Brandenburg, how much is there? Does that violate a rule?
That does not violate a rule. The court can allocate GAL fees however it deems fit. The difficulty is guardian ad litem in this case had sought my incarceration, if I can speak English, for non-payment of her fees when my ex-wife owed her fees as well. So in spite of the fact we had owed her equally, she went against me repeatedly to have me incarcerated for non-payment of her fees when I actually was paying more than my ex-wife was. So I believe it was a attempt to raw intimidation against me because that originally the fees were divided 50-50, but they were changed that I was responsible for 100%. After I brought up the problems with the guardian ad litem to the court, the fact that there was never any proper appointment, the fact that there was a retroactive appointment, the fact that there were over $7,000 in retroactive fees. When I brought up the problems of the guardian ad litem to the court, I was punished by Judge Arnold, who attempted to have me incarcerated, intimidated me.
We're going to stick with this point. Representative Lambert.
Thank you, Mr. Chairman. So it's my understanding that Judge Arnold approved $40,000 over the fee cap and tried to have you incarcerated for challenging those fees.
Right now, I have the documentation for $11,069.69 over the fee cap.
11,069.
So that's all the documentation I have at this point for that.
I just want to make sure that we're clear, and I'm sorry that I didn't get it, and I apologize for being late. $11,069 over the fee cap, while you complain about the jurisdiction and performance of the guardian ad litem. Means that Judge Arnold directs all of the fees to you and threatens you with incarceration for non-payment, while there's a question about whether or not the guardian ad litem was properly authorized by him in the court.
Correct.
And that's due process how?
Well, again, due process, I couldn't get a hearing on that. Her motions for fees, her motions to exceed were granted without hearing. My motions to address the underlying unlawful termination of contact with my daughter were not heard for 2.5 years. He would grant motions for fees within 30 days for her, over the cap, without a hearing, without an appointment from that woman. And I could not get into the court to have the underlying issue of my contact with my daughter even addressed by the court.
We have one more follow-up, just so we can keep moving forward.
You couldn't get heard by the court on the fees, or you couldn't get heard by the court on...
Both.
So you couldn't
We couldn't get a hearing for the fees. We didn't have a hearing.
You couldn't have a hearing on anything?
Right.
Did you have a hearing on anything at all?
Well, we had a hearing, a motion to compel my ex-wife who owed me, she was supposed to pay half of a custody evaluation fee. She refused to do that. Judge Arnold refused to enforce the order to have her pay that.
You had a hearing on that, is what your answer was?
We had a hearing, yes.
Yes, you did.
That was the only hearing we had.
Let's come back to you, Representative Lambert, so there's an end.
Well, I'm not finished. There's one more thing. There was a second hearing on July 27th of last year It was noticed as a hearing on vacating the unlawful order. However, that was not brought up. What was brought up was the issue of her fees, the guardians ad litem fees. So we spent the entire 3 hours talking about her fees, never once addressed the improper order that was the cause of the entire brouhaha.
Representative Morgan,
This is a friendly question this time. Could you run through the timeline of GAL Hamilton's involvement in your case? 'Cause I guess.
no, we're not going to do that, Representative. We're not down to that point yet. We're going to be down to
Let's
the
talk
bottom.
about the retroactive appointments and we can clarify why. So I understand
Well,
that.
if you don't mind, let's just run this with the GALs when they come up. You do this, you jump ahead persistently, we just can't do it. I can't stay. It's my job to run this. Let me bring it to you later. Let me bring it back to you later with the GALs. Representative Ean?
Yes, thank you. I'm having difficulty understanding how you couldn't be heard in the court. So were you a pro se?
Part of the time I was pro se and part of the time I was representing. Even with representation, I could not be here.
I don't understand how that works. If you would explain how that works. I
Well,
mean, you file papers and
right.
they get into an agenda and
They don't get into an agenda. They don't have to be ruled by the judge. They don't have to consider them.
We're going to follow up, yeah.
they don't have to be considered, but they have to be on an agenda.
No, they're not. The agenda is the docket, right?
Right.
So you guys have a docket here. You're going to hear these 3 petitions today, supposedly. They're docketed, basically. So when you go to a court in New Hampshire, you're not guaranteed docketing. So if happened with me, I brought in, and I have them, I have multiple motions to vacate the order that were just not ever heard, never decided upon for a year.
That was because the judge would not want to take up the order and
You wouldn't want to consider
and
it.
dismiss it? I mean, the
Would
judge
you be
has the
asking-
option of
He
dismissing.
could deny it. He could
Right.
dismiss it, he could deny it, he
Right.
could grant it, other
And is
things.
that
Doesn't do
indeed
anything.
what happened?
Doesn't dismiss it, doesn't grant it, doesn't do anything, it just sits there.
Why not?
Why not?
Where does it ignore?
I'm sorry.
Yeah, I appreciate you don't answer questions unless they go through the chair. So, very good try. Representative Lambert, actually, I believe it is your shot, though.
I don't want to waste my question on having him answer the obvious question of why not. But if you want to throw in the answer there, I'm certainly not going to waste that.
The answer of why not, though, is related to.
Her question.
Right, yeah, her question, which was a question of looking for a motive on the part of the judge, which unless it's expressed, I'm
No,
not
looking for
person to
procedure,
do.
not motive.
Right.
It's procedure.
Okay,
If
That's-
he has the option of
okay,
just
I see what you mean.
deciding not to take it up,
So, yeah, so talk to us about
thinks
that.
it's irrelevant or something.
That's one of the recommendations I've made to the committee, is that there must be mandatory docketing of a petition or motion that's presented to a court. It doesn't happen now. So this is one of the things that occurs, I've spoken to numerous attorneys in the state, that they're afraid to represent fathers in particular, but it can be mothers, doesn't really matter. But if a litigant gets a reputation as being a despised litigant, then the court can just refuse to docket a petition, a motion, anything. So you just won't get heard. And that's what can happen. So you won't get a hearing.
And so you had, at some point, I think you said you could provide us with a lawyer who would tell us about that.
Oh, I thought I could. I can't.
That's okay. Representative Lambert.
Thank you.